In January, the Wisconsin Supreme Court heard argument and then, in a conference following, adopted a rule which specifically allows mediators in family law cases to write and draft agreements between the parties. Is this a good idea or a bad idea? And I guess my response is somewhat nuanced. There are some good things about it, and there are parts of it that worry me. First of all, in the 30-plus years that I've practiced family law, anyone counting, I started at age 5, gray hair notwithstanding. The biggest change, I think, is the lessening of likelihood of going to trial of litigation. I started off in this firm coming out of the DA's office as the firm litigator. That was my job, was to try cases, and I tried quite a few. I think at one point probably 5, 7 or more divorce cases a year, some post-judgment cases. I was up in the family court commissioner's office, and that has dwindled over time, or I probably end up trying 1 case a year on average right now. And I think that's fairly typical of family lawyers everywhere, with the exception of a marginal few who believe in litigation and that helps people, is that society has come to the conclusion that litigation helps only lawyers, and especially in the field of family law, and especially where there are children, be they adult or minor children, that we help parties a lot more, helping them resolve their problems and getting along. How have we gotten to the point where we used to litigate a lot and we litigate very little now? And if you don't believe that, go to Flu this month and last month and look at the portion that says cases from Wisconsin. You're going to see very few. There are none in the month of, from February, that'll be in the March 1 Flu. Cases just aren't being tried, they aren't being litigated. So societal change may be some of it, but I think the biggest factor that I've seen, which has helped settle and resolve cases rather than litigating them, is mediation. And having been in mediation as a lawyer representing a client, I've been amazed any number of times where I've gone to mediation with a case that I thought we're probably wasting our time here and walked out with a settlement. And when we haven't walked out with a settlement, have gotten substantially close enough that we can settle the cases later. And then about a little over a year ago, after having been asked to serve as a mediator on a number of occasions, I went to mediation training and got certified as a mediator, and have done a few since then. Part of the reason mediation is so successful is it gives clients a view as to how a third party, in this case a mediator rather than a judge, might decide these issues. And the parties can, and frequently do, conclude that if this is how a third party would do it, a judge might do the same thing, and rather than spend the energy, time, and money to end up in a place where we can end up without spending that energy, time, and money by just agreeing, seems to make a whole lot of sense. And for those reasons, mediation has been incredibly successful in my experience, both as an attorney and as a mediator before I was certified, and as a certified mediator now, in helping people resolve these issues. And that's, I think, a very, very positive step, very positive progress in the practice of family law and trying to help people and trying to help families heal from the onslaught of divorce. That being the case, the question arises that once there's an agreement, what do the parties do next? And I think this new rule codifies something that's been happening anyway. I think that there are a lot of cases where the mediator has been writing an agreement up between the parties, and this rule just codifies that practice in making it ethical and appropriate for lawyers to do that. Is that a good thing or a bad thing? Well, it's a good thing in the sense that if the parties do come to an agreement, it doesn't do them any good unless somebody writes it up and the mediators there knows what the agreement is, and therefore the having the mediator write it up helps finally resolve the issue and put it down in writing and nail it down so that a court can approve it. It can be a negative in some sense, however, because it can put the mediator in a somewhat uncomfortable position. Don't forget that all law is semantics. I mean, that's it. All we have are words. There's no real science behind this. It's not like medicine, which is based on science. Our, quote, science is linguistics. It's choice of words. And choice of words can make a huge difference. We all know as lawyers the difference between the word may and the word shall. The choice of those words can make a huge difference in a case. My favorite example was Bill Clinton's famous line, which during his impeachment proceedings, when he was asked about a statement he made, and his response was, "It all depends on what the meaning of the word is." And whatever you think about Bill Clinton as a president or a human being, I think everyone agrees he's a brilliant lawyer, and the definition of the word "is" made a difference about whether or not he was prosecuted for perjury, and for that matter, maybe whether the impeachment proceedings had resulted in a conviction. So words are very important, and saying to the mediator, you draft an agreement but do it as a neutral, can, in certain conditions, in certain cases, create a conflict and a difficulty for the mediator because the choice of words are important. That being said, there are a lot of cases in mediation where it just doesn't matter. There are a lot of cases where what the mediator is mediating is, say, a placement schedule, and I can't imagine too much the wording difference between whether pickup is Friday at 5 o'clock, Friday at 6 o'clock, or Friday from school or whatever. And a lot of those minor issues, especially what I would say are parenting rather than legal issues, the wording of it really isn't critically important. Then there are a lot of cases where what the mediator is mediating are issues where the people can't afford lawyers, and that speaks to, certainly in Milwaukee County, the vast majority of people that go through court. These aren't people with huge amounts of money. These are people that are pretty much dividing up who pays what credit card and who gets what piece of furniture. It's in cases that are more complex than that, and they happen now more and more, where people with resources, with money, with issues to be decided, go to mediation without attorneys. And that's where I think the danger is. When I serve as a mediator, I want the parties to have attorneys unless the matter is a placement issue where attorneys just aren't needed. And I've done a couple where there just isn't enough money, or the particular single issue being mediated really doesn't require the parties to have an attorney. Anything more extensive than that, parties really need to have an attorney to tell them that this is or is not in their best interest, and when it comes to resolving the case, that the choice of words is one that effectuates what their intent is and works for them. One of the problems we have in family law when we draft these agreements is we're not only drafting what we think works now, but for what we think will be in the best interest of our client in the foreseeable future. So as a mediator, I want the parties to have lawyers, and even if the Supreme Court thinks it's perfectly fine for attorneys to draft these agreements as mediators, I think it's a whole lot better to have the parties have their own attorneys draft the agreements. Mediator can review it, can try to have the parties agree and mediate any differences between the wording. But words are important, words are meaningful, and parties should have the benefit of knowing what's in their best interest before agreeing to any.